put it up here. Oh.
Somebody.
Oh, no, what? I don't think you need one. There's a plug there.
Okay, they're down at the plunge. I'm going to go right before that.
Good evening. Thank you all for coming. We're going to be getting started in just a few minutes as soon as we get a space set up for an overhead projector that some people want it. In the meantime, those of you who wish to testify, if you would fill out one of these separate sheets, please, and give it to this lady over here in the blue at the middle door. I will be calling witnesses to testify from these sheets, not from the general signage. Thanks. There's some additional ones up there. Yeah.
have?
Oh, about 30 seconds.
30 seconds? Sure. 30 only.
I just give all that boring stuff to start with. We can skip right it.
Well,
Basically, they gave the board a rule. Okay. You want to do a sound check?
It's just the standard city council.
Good evening. Once again, before we get started, anyone wishing to talk tonight, if you would please fill out one of these forms and bring it up here to me. Just set it on the table and we'll get them organized and we'll call people in the order that we have received them. This hearing is called to order. Let the record show it is approximately 6:10 p.m. on April 5th, 1995. This hearing is taking place in the City Council chambers of the Missoula City Hall, 201 West Spruce, Missoula, Montana. This is the time and place set for the rulemaking hearing in the matter of the proposed amendment of Rules 16.8.1404, 1413, and 1429 of the Administrative Rules of Montana. The proposed amendments deal with opacity requirements and limitations at Kraft, Pulp mills. My name is Will Hutchison. I've been designated the presiding officer for this hearing for the Montana Board of Health and Environmental Sciences. Montana law requires hearing officers at rule hearings to read the notice of function of the Administrative Code Committee, and it is as follows. The Administrative Code Committee reviews all proposals for adoption of new rules or amendment or repeal of existing rules filed with the Secretary of State. The committee has the authority to make recommendations to an agency regarding the adoption, amendment, or repeal of a rule, or to request that the agency prepare a statement of the estimated economic impact of a proposal. In addition, the committee may poll the members of the legislature to determine if a proposed rule is consistent with the intent of the legislature, or during a legislative session, introduce a joint resolution directing an agency to adopt, amend, or repeal a rule. The committee welcomes comments from the public and invites members of the public to appear before it or to send in written statements in order to bring to the committee's attention any difficulties with existing or proposed rules. The committee's address is room 138, State Capitol, Helena, Montana. Notice of this hearing was published in the Montana Administrative Register in MAR Notice Number 16-2-492 on February 23rd, 1995. As required by Montana law, I am to read to you the major provisions of the hearing notice. Is this better? No? Is this better? Okay, sorry. Paragraph 2 of the hearing notice sets forth the proposed amendments in their entirety, and because of their length, I will not read them into the record. However, hearing notices are available at the speaker's podium up here by me or at the side table here. Paragraph 3 of the hearing notice states the rationale for the proposed amendments as follows. The board is proposing these amendments to the rules as necessary to resolve a declaratory ruling proceeding before the board brought by Stone Container Corporation to provide greater consistency to the opacity limits for different age classes of Kraft pulp mill furnaces, and to provide a method for continuously monitoring the opacity of emissions from these furnaces. On November 22nd, 1992, the Air Quality Bureau of the department issued Stone a notice of an air quality permit modification for Stone's Kraft pulp mill in Missoula, including a specific opacity limit of 20% for Stone's number 4 recovery furnace installed in 1972. Past permits had not specified the opacity limits for Stone's recovery furnaces. Stone's number 3 recovery furnace installed in 1966 is subject to a 40% opacity limit under Administrative Rule of Montana 16.8.1404 subparagraph 1. And Stone's number 5 recovery furnace installed in 1980 is subject to a 35% new source performance standard under Administrative Rule of Montana 16.8.1404 subparagraph 4. Stone appealed the permit to the board. On June 8, 1993, Stone withdrew its appeal and filed a petition for declaratory ruling with the board, asking the board to rule that, under Administrative Rule 16.8.1404 sub 4 sub D, the applicable opacity limit for Stone's number 4 recovery furnace is 35%. The department contested Stone's petition, asserting 16.8.1404 subparagraph 2 requires a 20% opacity limit. On July 15, 1994, the board granted Stone's petition and ordered that, under 16.8.1404, the applicable opacity limit for Stone's number 4 recovery furnace is 35%. On November 2, 1994, the board granted a petition for rehearing by the department, and subsequently the board scheduled rehearing for November 18, 1994. Prior to that rehearing, the department and Stone agreed to attempt to resolve the matter by submitting a rulemaking proposal to the board. The terms of that agreement are embodied in this notice of proposed rulemaking. As a Kraft pulp mill recovery furnace, Stone's number 4 recovery furnace is in the new source performance standard category, but was constructed prior to the September 24, 1976 effective date of the 35% NSPS opacity limit. Application of the 20% opacity limit under 16.8.1404 subparent 2 results in a more stringent opacity limit for a boiler built in 1972 than the limit that applies to the number 5 recovery boiler installed in 1980 or any new Kraft pulp mill recovery boiler installed in the future. The proposed amendments would result in a uniform 30% opacity limit for recovery boilers installed after November 23, 1968, and would lower the limit for boilers installed on or before November 23, 1968 from 40% to 35%. The proposed amendments would also extend to all Kraft pulp mill recovery boilers, including Stone's number 3 and number 4 boilers, the continuous 6-minute average opacity monitoring requirement that now applies only to recovery boilers installed after September 24, 1976. Presently, opacity compliance by Stone's number 3 and number 4 recovery boilers must be determined by periodic visual inspection under EPA Method 9. Paragraph 4 of the hearing notice indicates that interested persons may submit their data views or arguments either orally or in writing at this hearing. Written data views or arguments were to be submitted to Yolanda Fitzsimmons, Secretary to the Board, no later than April 5th, 1995. Authority of the Board to make the proposed rule amendments is contained within Section 75-2-111 and 203 Montana Code Annotated. The order of presentation of testimony tonight will be as follows. First, the department will be given the opportunity to summarize or otherwise explain the proposed amendments and its rationale for proposing them to the board, and to offer any supporting testimony. Following that, we will move to the statements of proponents. Following the proponents, we will move to the statements of opponents. Following the opponents, we will listen to the statements of anyone else wishing to be heard by the board on this matter. I will be calling witnesses from the sign-up sheets that have been filled out and collected. Those sheets are available by the speaker's podium, by the side table, and by the back door. If anyone wishing to speak has not filled out a slip, please do so at this time and bring it up to me. If you wish, you may submit a written copy of your testimony to me or to the recorder to my right. This is an informational type hearing. Rules of evidence are not applicable. Witnesses will not be sworn or subject to cross-examination. However, the board, through the hearing examiner, that's me, may direct questions or comments to witnesses. Testimony must be relevant to the matter at issue in this hearing. Because of the large number of people that have indicated a desire to testify, I'm not going to impose any time limitation, but I would ask that out of respect to the ability of everyone who wishes to speak to be able to speak, that you keep your comments to the point and as short as possible. Because we are taping this hearing, all witnesses presenting oral testimony will be asked to please come forward to the podium. Prior to making your statements, please identify yourself by name, address, and affiliation, if any. With that, we will move to the presentation by the department. Mr. Chafee. Mr. Russo.
For the record, I'm David Russoff, attorney for the Department of Health and Environmental Sciences, assigned to the Air Quality Division. The Department of Health and Environmental Sciences is proposing that the Board of Health and Environmental Sciences amend ARM 16.8.1404, 16.8.1413, and 16.8.1429. Chuck Homer of the Department's Air Quality Division permitting staff will describe each proposed amendment to those rules. Before he does, I'd like to explain the history of this rulemaking proposal. On November 25, 1992, the Department issued a notification of permit modification for air quality permit number 2589-03, held by Stone Container Corporation for its Kraft Pulp Mill in Missoula. One of the permit modifications was inclusion of specific capacity limits for Stone's recovery boilers. Prior to that time, Stone's permit, like other air quality permits, did not include specific capacity limits. Including specific capacity limits was part of an effort by the Air Quality Division to include reference to all applicable requirements in its air quality permits. Based upon the requirements of the Department's generic capacity rule, ARM 16.8.1404, the permit modification added a 40% opacity limit for Stone's number 3 recovery boiler, a 20% opacity limit for the number 4 recovery boiler, and a 35% opacity limit for the number 5 recovery boiler. On December 9, 1992, Stone appealed the permit modifications to the board. Among other issues, Stone asserted that a 20% opacity limit on the number 4 recovery boiler constituted a reduction of the limit that Stone had been operating under for that emission source. Over several months, Stone and the Department resolved all the permit modification issues except the appropriate opacity limit for the number 4 recovery boiler. Stone withdrew its appeal so that the Department could issue the permit, and on June 8, 1993, Stone filed a petition for declaratory ruling with the board to resolve the remaining opacity issue. The Department's present rulemaking proposal is intended to resolve that declaratory ruling proceeding. Stone has asserted that ARM 16.8.1404 can be read to allow a 35% opacity limit for Stone's number 4 recovery boiler because that emission source is in a new source performance standard, or NSPS standard category of emission sources for which the limit is 35%. The department's position has been that ARM 16.8.14.04 requires a 20% opacity limit for the number 4 recovery boiler, and that the NSPS exception in the rule applies only to sources that are actually subject to NSPS regulations. After an additional year of negotiations and formal discovery, including interrogatories and depositions, the department moved for summary judgment last spring, in the spring of 1994. After the parties filed extensive briefs on the issue, the board denied the department's motion and scheduled a contested case hearing for July. After a contested case hearing on July 15, 1994, the board voted to grant Stone's petition for declaratory ruling. The board ruled that ARM 16.8.14.04 allows a 35% opacity limit on Stone's number 4 recovery boiler. The department petitioned the board for rehearing. On November 2, 1994, by a 4-3 vote, the board voted to reconsider its decision in the case. The board scheduled rehearing for November 18th. After the board voted to reconsider its decision, Stone renewed settlement discussions with the department. The department contacted representatives of the Missoula City County Health Department, the Missoula City County Air Pollution Control Board, and asked them to participate in the settlement discussions. The department was informed that Missoula City County representatives would not participate in the settlement discussions and would consider only a settlement proposal brought to a public meeting of the Missoula Board. Stone's attorney and I relayed settlement proposals for a couple of weeks. After that, on November 18th, shortly prior to the scheduled rehearing, Stone and the department reached an agreement on the terms that are now contained in the proposed rulemaking. Stone agreed that any settlement affecting the opacity limit for the number 4 recovery boiler would be implemented through a formal public rulemaking proceeding. This had been something that the parties had not been able to agree on in prior settlement discussions. To more fully understand the proposed rule amendments, it's necessary to consider the requirements of the department's present opacity rule, the history of that rule, and the application of that rule to Stone's 3 recovery boilers. The board first adopted a rule regulating the opacity of stationary sources of air pollution in 1968. The board substantially amended the rule in 1978 and added the NSPS exception at that time. The department's opacity rule, ARM 16.8.14.04, presently provides in relevant part as follows. Subsection 1, no person may cause or authorize emissions to be discharged into the outdoor atmosphere from any source installed on or before November 23, 1968 that exhibit an opacity of 40% or greater averaged over 6 consecutive minutes. Subsection 2, no person may cause or authorize emissions to be discharged into the outdoor atmosphere from any source installed after November 23, 1968 that exhibit an opacity of 20% or greater averaged over 6 consecutive minutes. Subsection 4D provides that this rule does not apply to emissions from those new stationary sources listed in ARM 16.8.14.23 for which a visible emission standard has been promulgated. ARM 16.8.14.23 is a department rule that requires the owners and operators of stationary sources to comply with applicable NSPS standards. NSPS regulations are promulgated by EPA, or the Environmental Protection Agency, and apply to sources constructed or substantially modified after the effective date of the applicable NSPS regulation. EPA promulgated NSPS regulations for Kraft pulp mill recovery boilers in 1976. The regulations require a 35% opacity limit for Kraft pulp mill recovery boilers constructed or substantially modified after September 24, 1976. Stone's newest recovery boiler, the number 5 boiler, was installed in 1980 and is subject to the NSPS 35% opacity limit. Stone's number 3 recovery boiler, installed before 1968, is subject to a 40% opacity limit under ARM 16.8.14.04. Following is a summary of the settlement between Stone Container and the department. Again, the parties agreed to implement the settlement through a formal public rulemaking proposal to the state board. The parties agreed to propose that the board amend the department's air quality rules to provide that the opacity limit will be 35% averaged over 6 consecutive minutes for Kraft pulp mill recovery boilers installed on or before December 23, 1968, and 30% for Kraft pulp mill recovery boilers installed after that date. This would result in the following limits for Stone's recovery boilers. For the number 3 boiler, the new limit would be 35%. present limit is 40%. For the number 4 boiler, the new limit would be 30%, and the present limit is the limit that's in dispute in Stone's declaratory ruling proceeding. However, under the State Board's September 26, 1994 ruling on Stone's petition, the opacity limit is 35% on the number 4 boiler. The new limit on the number 5 boiler would be 30%. Presently, the limit is 35. The parties agreed to propose that the board amend the department's rules to provide that continuous opacity monitors, subject to all new source performance standard monitoring requirements, will be installed, calibrated, operated, and maintained for every Kraft pulp mill recovery boiler. The parties agreed to propose that the monitors may be used as a direct measure of compliance with the 6-minute average opacity limit. Neither party waived its right to seek any necessary further rule change in the future. The parties agreed that if the board adopts the proposed rule amendments, Stone will withdraw its petition for declaratory ruling, and the parties will jointly ask the board to withdraw its September 16th order. The opacity limits that would be included in the proposed rule amendments are more stringent than the limits established under the board's order. The board's order set the limits at 40%, 35%, and 35% for the number 3, 4, and 5 recovery boilers, respectively. The 30% opacity limit that would apply to Stone's number 4 recovery boiler is less stringent than the 20% opacity limit included in Stone's 1992 permit modification that Stone appealed, but more stringent than the 35% NSPS opacity limit that would apply to any new Kraft pulp mill recovery boiler installed today under the present Montana and federal rules. During the declaratory ruling proceeding, the department conducted a couple of surveys of opacity limits on Kraft pulp mill recovery boilers in other states. I conducted a survey of all states last December and found the following limits in the states that have Kraft pulp mills and or specific Kraft pulp mill opacity rules. For Alabama, by general rule, the limit is 20%. In Arizona, by general rule, the limit is 40%. In Arkansas, by general rule, the limit is 20%. In Florida, a specific Kraft pulp mill rule is 45%. In Georgia, by general rule, the limit is 40%. In Idaho, a specific Kraft pulp mill rule establishes a 40% limit. Louisiana, a specific Kraft pulp mill rule establishes a 40% limit. In Maine, a specific Kraft pulp mill rule sets a 30% limit. Michigan, by general rule, the limit is 20%. North Carolina, a specific Kraft pulp mill rule that applies to boilers installed after 1971 sets a 35% limit. The only rule that I could find applicable to Ohio was for the Southeast District, and by general rule, the limit is 20%. In Oregon, a specific Kraft pulp mill rule sets a limit of 35%. South Carolina, a specific Kraft pulp mill rule sets a limit of 40%. Tennessee, Kraft pulp mill rule, 35%. Virginia, 35%. Washington, 35%. Wisconsin, 20%. By general rule, however, there's a 40% limit that applies to sources constructed before April 1st, 1972. And the survey is, I mentioned this survey merely to indicate where our proposed amendments would fall in the range of other state limits. The survey indicates that the limit proposed by the Department for Recovery boilers installed prior to 1968 is as stringent or more stringent than the limits in 11 of the 17 states having Kraft pulp mills and or specific Kraft pulp mill rules. Survey indicates that the limit proposed by the Department for Recovery boilers installed after 1968 and which would apply to Stone's number 4 recovery boiler is as stringent or more stringent than the limits in 12 of the 17 states having Kraft pulp mills and or Kraft pulp mill rules. The issue in this case has been unresolved since Stone appealed its permit modification in 1992. While the Department's position is that the present opacity limit for Stone's number 4 recovery boiler under ARM 16.8.14.04 is 20%, since Stone's permit appeal, Stone's permit has contained specific opacity limits for the number 3 and number 5 boilers, but not for the number 4 recovery boiler. Presently, compliance with the opacity limits on the number 3 and number 4 recovery boilers requires a visual inspection. Under the rulemaking proposal, the department would have definite opacity limits on all 3 of Stone's recovery boilers, and through the continuous monitoring requirement, would have a greatly increased ability to determine compliance with those limits on an around-the-clock basis. EPA informed the department in the spring of 1994 that if the board granted Stone's petition for declaratory ruling, EPA would not disapprove the ruling as violating the PM10 control plan for Missoula County. EPA notified the department by letter earlier this week that EPA could approve the proposed rule amendments as a state implementation plan revision because the changes do not appear to affect the stringency of the PM10 mass emission limits in Stone's permit, and because the changes are no less stringent than the new source performance standards for Kraft pulp mills. EPA stated that it will make a final determination if the board adopts the proposed rule amendments and the changes are submitted to EPA as a state implementation plan revision. Copies of Stone's current air quality permit and EPA's letter are attached to my written testimony, which I've already filed with the reporter. Thank you.
Thank you, Mr. Russo. Is there anyone else from the department that's going to make a presentation? Mr. Homer?
For the record, my name is Charles Homer. I'm an air quality specialist with the permitting section of the Air Quality Division of the Department of Health and Environmental Sciences. Today, the Department of Health is proposing amendments to ARM 16.8-1404, visible air contaminants, 1413, sulfur emissions from Kraft pulp mills, and 1429, the incorporation by reference section. These amendments are proposed to establish specific opacity limitations for recovery furnaces at Kraft pulp mills. The proposed amendments also contain monitoring, record-keeping, and reporting requirements consistent with federal requirements. The proposed amendments change the title of ARM 16.8-1403, eliminating the reference to sulfur emissions, define cross-recovery furnace, and straight recovery furnaces, definitions identical to the corresponding federal definitions. In addition, the proposed amendments establish opacity limitations of 35% for recovery furnaces at Kraft pulp mills installed on or before November 23, 1968, and 30% for those that were installed after November 23, 1968. These limitations will supersede any other applicable opacity limitation contained in a state air quality rule and ARM Title 16, Chapter 8. As some background, we're talking about opacity in this rule. Opacity is a measure of the density of a plume. Opacity is expressed in a percentage manner, and it is the amount of light obstructed by a plume. Uncombined water vapor, what is generally referred to as steam, contained in a plume cannot be counted when determining opacity. As an example, if 50% of the background is obscured by a plume, then the opacity of that plume is 50%. If 25% of the background is obscured by the plume, then the opacity is 25%. Opacity is generally determined by an individual making a visual observation using a specific EPA-defined method. Opacity may also be determined using in-stack continuous opacity monitors or COMs. The proposed amendments that we're hearing today require installation and use of combs on all recovery furnaces at Kraft pulp mills to demonstrate compliance with the appropriate opacity limitations. The combs will be required to comply with established federal monitoring, record-keeping, and reporting procedures. Compliance with the opacity limitations may also be determined using visible emissions observation when the combs data is unavailable or can be shown to be inaccurate. The proposed amendments also require submittal of excess emission reports using forms and procedures specified by the department. Currently, the department conducts inspections or site visits at stone containers semi-annually. During the site visit, an inspector observes the plumes at a facility. If a plume appears to be in violation of a standard, an opacity observation is done at that time. At times, it may be very difficult or impossible to make an accurate opacity observation in stone due to specific conditions at the site. There may be multiple plumes interfering with each other, plumes containing uncombined water vapor or what is commonly referred to as steam, plumes situated against a poor background. Installation of the cones will give the department the ability to determine stone's compliance with the opacity limitations on a continuous basis. As part of the Title V operating permit program, the EPA has proposed an enhanced monitoring rule. This rule will require increased monitoring at sources subject to the Title V rule, such as stone container. They will require this enhanced monitoring to demonstrate compliance with existing limitations. However, this proposed rule is under challenge, and the final contents of the rule are in doubt at this point. Current indications are that the enhanced monitoring rule will not require continuous monitoring in all cases. The department does not believe that they can rely on the enhanced monitoring rule to require continuous monitoring at stone's recovery boilers. Now I'd like to specifically go through the amendments as they are contained in the notice. Starting with ARM 16.8-1404, sub 4, visible air contaminants, a new section F is added exempting recovery furnaces from the general opacity standards applicable to sources without specific opacity standards. ARM 16.8-1413, in the title, the reference to sulfur emissions is removed from the title, since this section will now contain all rules specific to Kraft pulp mill rules. In section ARM 16.8-1413, definitions of cross recovery furnace, and straight recovery furnace are added in 1B, 1F, and 1H respectively. The existing sections are renumbered accordingly. These definitions are identical to the corresponding definitions in the Federal New Source Performance Standards, 40 CFR Part 60, Subpart BB, Standards of Performance for Kraft Pulp Mill Rules. In Section 7 of ARM 16.8-1413, the term TRS is added to the current wording to clarify that only the total reduced sulfur or TRS standards are to be based on average daily emissions. Previously, this rule only referred to TRS emissions, so it referred only to all emission standards, and that's what was changed in that section. A new Section 8 is added to ARM 16.8-1413, limiting the opacity of emissions from recovery furnaces installed on or before November 23, 1968 to 35%, averaged over 6 consecutive minutes. For recovery furnaces, this opacity limitation supersedes any other opacity limitation contained in the chapter, including 1404 and 1423. A new Section 9 is added, limiting the opacity of emissions from recovery furnaces installed after November 23, 1968 to 30%, average over 6 consecutive minutes. A new Section 10 is added to 1413 that requires an installation and use of continuous opacity monitors on all recovery furnaces at Kraft pulp mills. The opacity monitors will be required to comply with established federal monitoring, record-keeping, and reporting requirements contained in 40 CFR Part 60, Appendix B, Performance Specification 1. A new Section 11 is added to ARM 16.8-1413, specifying that the opacity monitors are to be the primary method of determining compliance with the applicable opacity limitations. Compliance may also be determined using visible emissions observations according to 40 CFR Part 60, Appendix A, Method 9, when the opacity monitor data is unavailable or inaccurate. A new Section 12 is added to 16.8-1413, requiring submittal of excess emission reports using forms and procedures specified by the department. For the purposes of the report, the excess emissions refer to any 6-minute average opacity of 35% or greater for recovery furnaces installed on or before November 23, 1968, or 30% or greater for any recovery furnace installed after November 23, 1968. In ARM 16.8-1429-2, the incorporation by reference section, new sections B and C are added, incorporating by reference 40 CFR Part 60, Appendix A, Method 9, the method for visually determining the opacity of a plume, and 40 CFR Part 60, Appendix B, Performance Specification 1, the requirements for operation of a continuous opacity monitor. The change in opacity limitations that are proposed in this rule will not affect any existing allowable mass particulate or PM10 emission limitations that currently apply to stone container. So there will be no increase in allowable particulate emissions from stone containers' existing recovery furnaces. The existing mass particulate and PM10 emission limitations at Stone's recovery furnaces are as follows. For the number 3 recovery boiler, 979 pounds per day or 40.79 pounds per hour. For the number 4 recovery boiler, 1,253 pounds per day or 52.21 pounds per hour. For the number 5 recovery boiler, 633.6 pounds per day or 26.4 pounds per hour. These particulate emission limitations were developed as part of the state implementation plan to bring Missoula's PM10 levels into compliance with federal ambient air quality standards. The change in the opacity standards will not affect Stone's compliance with the SIP. Since the change in the opacity limitation will not affect the capacity of the facility or the combustion process, the characteristics of the particulate emissions, particle size distribution, chemical makeup, ambient impact, etc., from the recovery furnaces, those things should not change due to the change in the opacity. The department has provided notice of this rule hearing in accordance with the Montana Administrative Procedures Act through publication in the Montana Administrative Register, and the department recommends adoption of the proposed amendments to ARM 16.8-1404, ARM 16.8-1413, and ARM 16.8-1429 as published in the Montana Administrative Register. I am leaving a copy of my testimony with the hearings officer.
Thank you, Mr. Homer. Is there anyone else from the department that is going to testify at this time? We will then move to the statements of proponents. Don Seba.
My name is Don Serba. I live at 216 Sentinel Avenue here in Missoula. I'm a lifelong resident of Montana and of the city of Missoula. I appreciate the opportunity to speak to you tonight. Stone Container has invested a large amount of time and money to continually upgrade its Frenchtown paper mill, not only to increase productivity and quality of its product, but to help reduce pollution to air and water quality. A few examples of this, to take a short amount of your time. In 1988, Stone Container built a color removal plant which removes waste fiber from mill effluent, cost of $5 million. 1990, aeration basin upgrade to increase bacterial breakdown of mill effluent and reduce H2S odors, $750,000. In 1990, Stone Container built an OCC plant to recycle cardboard and other waste paper, thus reducing landfill use and off-road use, $16 million. 93, installed state-of-the-art chip screening system that produces more yield per ton of raw fiber and has significantly reduced chemical use at the mill. 94, installed a treatment system on emergency spill pond to reduce H2S odors, $100,000. Slated for startup this spring, sludge dewatering system that will collect sludge for mill fluid and use it for fuel instead of hauling it to the local landfill, $1.3 million. Plus these expenditures, Stone Container spends approximately $6 million per year on environmental operating costs and employs 3 full-time environmental engineers. It hardly seems that Stone Container is not environmentally conscious. I believe the real question is not one of opacity, but one of control. It seems that certain members of the City Council Health, or the City County Health Department are using opacity question is a tool to try and wrestle control away from the state board, not for clean air, but for personal power. Last meeting, Mr. Garrett Smith, an associate professor of chemistry at the University of Montana and a member of the Missoula Air Pollution Control Board, stated only 5% of particulate in Missoula County can be attributed to stone container. I believe this number to be correct and ask the state board to look at all the facts before mandating unreasonable opacity limits for number 4 recovery boiler. Thank you.
Thank you, Mr. Serban. Ed Scott.
Good evening. For the record, my name is Ed Scott, and I am the Director of Environmental Affairs at Stone Container, Missoula Mill. Let me start by saying that the Missoula Mill strongly supports the proposed rule change. This proposed rule change resolves a long-running dispute between the mill and the Air Quality Department in a way that fully protects important environmental values. Stone urges the board to adopt the proposal without modification. Contrary to comments I've heard in the past, this rule modification is not a relaxation of any standards, and it will not result in any increase in emissions from the mill's recovery boilers. As a matter of fact, this proposed rule change works to further reduce actual opacity and particulate emissions from all three recovery boilers, which, by the way, are already emitting only a third of their allowables. Let me elaborate on my reasoning and basis for supporting this rule change. When assessing the value of this proposed rule or any environmental regulation, I review and consider 3 basic questions. Number 1, is the regulation stringent? Number 2, is the regulation enforceable? Number 3, is there an environmental benefit regarding the rule? When considering the question of stringency, one would have to answer yes when reviewing this proposed rule. Let me explain. First, this proposed rule, the 6-minute opacity standard in Mills No. 3 recovery boiler, was installed in 1968, would be reduced from 40% to 35%. This is equivalent to the federal new source performance standard set for new recovery boilers. Secondly, the 6-minute opacity standard on Mills No. 4 recovery boiler, which was installed in 72, and the No. 5 recovery boiler, which was installed in 1980, would be set at 30% opacity, which is even more stringent than the federal new source performance standard. In summary, as a direct result of this proposed rule change, all of the mill's recovery boilers, which range in age of 15 to 27 years, would face opacity standards equivalent or more stringent than those applicable under federal regulations for new recovery boilers. When considering the question of enforceability, one would have to say that this regulation is enforceable. Let me explain. First, under the existing opacity rule, the opacity emissions from the Mills No. 3 and No. 4 recovery boilers are not currently monitored with a continuous emissions monitor. They're monitored infrequently by a human-certified smoke reader employing EPA Method 9. Many times, because of bad weather, nightfall, it is impossible to read the stacks. In comparison, under the new proposed rule, the mill will be required to continuously monitor and report opacity emissions on both of these boilers using a continuous opacity monitor, as is already being done on No. 5 boiler. In other words, the proposed rule makes use of newer technology to replace periodic human observations with continuous mechanical opacity monitoring. Secondly, the proposed rule is clear and unambiguous. In other words, the requirements are easy for the regulating agency and industry to understand. These are 2 factors that lead to more enforceability. And finally, when considering the question of the impact this proposed rule will have on actual emissions from these 3 recovery boilers, one would have to say the rule reduces both opacity and particulate emissions from all 3. As I've stated previously, this proposed rule is not a relaxation of any standards, and it will not result in any increase of emissions. As a matter of fact, this modification works to further reduce emissions from all 3 boilers. In past testimony, I have personally projected that this proposed rule would result in a reduction in overall opacity and particulate emissions from the 3 recovery boilers. This projection was based on more stringent opacity limits in conjunction with additional monitoring requirements, resulting in quicker response times to emission upsets. I'm happy to say that over the past few months, at a Stone Container, we have been able to verify this theory by implementing the proposed opacity limits voluntarily and monitoring requirements on each boiler. In other words, all 3 boilers have been operating and been monitored as if the opacity standards and monitoring requirements are already in effect. Thus far, the data indicates that under the proposed rule, each boiler emits about 33% less particulate and opacity than it did while operating under the existing opacity rule. So to sum up, the proposed rule will result in more stringent rules than apply now, and for the first time, the rules will be enforceable as a practical matter, and this adds up to solid net benefit to the environment. Thank you.
W.G. Stewart. Can you hold up this thing, make sure we have our tape on? Okay.
Good evening. I'm W.G. Stewart. I'm General Manager of the Stone Container Mill in Missoula. My comments tonight are primarily to thank and commend the State Board for conducting this meeting here tonight. I think it's proper that this meeting be held in Missoula. Throughout the course of these negotiations or proceedings, citizens of Missoula and representatives of the local pollution board have been very much involved in the process, and I commend the State Board for conducting this meeting here tonight. As has been demonstrated well by Ed Scott and presented well by the State Department, the all-encompassing regulation that we are reviewing tonight is certainly beyond what we would have expected when we first entered into these discussions nearly 2.5 years ago now. An issue that once focused strictly on number 4 recovery, for which we seek clarification specifically on a specific issue on number 4 recovery, has now evolved into a proposed rule that encompasses all of our recovery boilers. Now, I can assure you, I can assure the board that had we not collectively taken into account the comments, the feelings, the testimony of so many of the folks here in Missoula, the proposed rule would not be structured as it is today. We would have been determined to keep the focus on the issue at hand at the time, namely number 4 recovery boiler. The proposed rule now is comprehensive. It redefines for all parties what the expectations are. Both the regulator and the regulated understand up front all the terms, conditions, expectations of the rule, and taking into account the strong feelings and expressions of the folks here in Missoula, we support the proposed rule that will, in essence, lower the opacity standards for all recovery boilers, and in many ways make them competitive with and as stringent as any other operations of its type in the business. But again, I thank you for presenting all of us here tonight the opportunity to address the issue. Thank you.
That concludes the sign-up sheets I have from proponents. Is there anyone else wishing to speak as a proponent? Yes, sir.
I had signed up and I didn't list myself as either proponent or opponent. I wanted to hear some of the background, and I would like to speak as a proponent, if I may.
Yes, you may. Please come forward.
My name is Steve Overholt. I'm at 4275 DJ
in Missoula, and I don't really have any affiliation. I came here honestly tonight thinking from what I had read in the papers, etc., that maybe these rules were not in the best interest of Missoula, but after hearing how they work and what the continuous opacity monitors are going to be installed, I feel that's very important. In the early 1980s, I used to work at the stone container mill. Back then it was Champion, and my job was monitoring the opacity, the air pollution emissions from the mill. And for 2 years I did that, so I got to understand pretty well when I was driving into work in the morning by looking at the plumes whether we were in violation or not. And I understand that you can not monitor the emissions very well by a visual method, because as they were saying, at night, in the fog, etc., it's hard to tell. If you get those continuous opacity monitors on those stacks, you're held to the limit all the time. Not just, apparently twice a year somebody comes in and makes the visual inspection. I feel that by getting those continuous monitors on there, you're going to have an enforceable standard, one that if they violate, there will be a clear record of violation, and they can be held to the standard. And from what I've heard, it's a reasonable standard compared to the other states. So as I said, when I came here earlier, I thought that maybe that wasn't the best rule, but after hearing the evidence, getting those continuous monitors on there, I think, is a great thing, and it will be better for the community. Thank you.
Thank you, sir. Anyone else wishing to speak as a proponent? We will then move to the statements. Yes, sir.
My name is Louis Ball. I live at 6900 Butler Creek. I am an employee at Stone Container, and I have been involved in air pollution monitoring in one form or another, water pollution, quality control, the entire time I've been at the mill. Currently I'm involved, and I have been for the last 15 years, in monitoring the TRS SO2, both stacks and just more recently at the outflows at Site 1A and 2. I'd like to commend the state and the agreement that you have come to recognize for the emissions monitoring. This will give the operators a tool with which to cease any violations that occur, rather than wait until somebody has notified them that there is a problem. The operators that I work with constantly utilize the data that we collect and we display before them to change their boilers so that they can eliminate as soon as possible. We have good operators. They need more tools. You've just given them another tool in the opacity monitoring system. I think this is going to be another tool with which they can work, and the idea is not to catch somebody after they've slowed down from speeding, but to catch them as soon as they start and stop it. And that's what the operators want to do out there. They live in this valley, their families live here, and the ones that I work with daily are concerned about the valley. They just need more information to work with. So thank you for what you're recommending.
Any other proponents? We will then move to the statements of opponents. For the record, I will note that 2 written comments were received prior to the start of this hearing in the mail. The first one was from Carol Allette in a letter dated April 4th, 1995. She opposed the rural package. The second one was from Rich Day director of the Northern Rockies Natural Resource Center in Missoula. In a letter dated April 4th, 1995, he also opposed the proposed rule package. First speaker as an opponent will be Barbara Evans.
Thank you for allowing me to speak. I'd like to clarify that I am not an opponent. I am not a proponent. I'm not even opponent. My name is Barbara Evans, and I am a county commissioner. I wish to state that I am not participating in any statement or position of the Board of County Commission because I have been advised by the county attorney's office that my husband's employment at Stone Container creates a potential conflict of interest which raises questions regarding my participation in any commissioner action on this matter. Thank you.
Thank you, Commissioner. Fern Hart.
Thank you. My name is Fern Hart. I am County Commissioner of Missoula County, and the following are for your record. The Missoula Board of County Commissioners welcomes this opportunity to participate in a formal hearing with an examiner and to be a part of the public record concerning the proposed changes to ARM 16.8.1404. We are especially pleased that the hearing is being held in this community rather than in Helena. We have learned from experience that our citizens respond to the governmental process when we are in their local area and include their comments in our decision-making process. As a board, we request that you consider the following comments in deliberating the proposed changes. 1. The number 4 recovery boiler at the Frenchtown Pulp Mill was built in 1972 and governed by the 20% opacity rule that was clear and unambiguous. Additions to the mill and additions to the opacity rule have not changed this fact. The existing rule should be enforced. We do not believe that the rule should be changed to accommodate the inadequate precipitator on the boiler. Number 2, if I could, as a representative of this county, I would ask that this be a very understanding group, that we in Missoula offer a respectful opportunity for everyone to make their comments. We should be proud in Missoula to be a good audience. Number 2, any action considered by the Board of Health and Environmental Science should have a beneficial impact on air quality, which would be at least equivalent to the enforcement of the 20% rule. Further, an assessment of equivalency should be based on a thorough analysis using reliable data. Number 3, the decision of the Board of Health and Environmental Science to allow use of a negotiated rulemaking process to resolve a violation of a clear and unambiguous requirement is troublesome because it has excluded the interests of the Missoula citizenry. For these reasons, we request that the Rule 16.8.1413 parentheses 8 be modified to require that any Kraft recovery boiler built after 1968 should meet a 20% opacity requirement. It is our understanding that the number 5 recovery boiler can easily meet this standard. We make this request because the Missoula Valley is a very sensitive airshed, and we all need to lessen our impact as much as is reasonably possible. It is not unreasonable to expect compliance with a 27-year-old rule. This is especially true when you consider that all other sources in Missoula County built since 1968 must meet the 20% opacity rule, and in many cases, the 10% rule. We would consider that a rule to meet this standard could be met with a proposed compliance schedule, which would allow a time to comply. We would strongly suggest a time certain. Our goal is to move toward greater compliance as we fulfill our obligations to protect the public health. Thank you for this opportunity.
Michael Kennedy.
My name is Michael Kennedy. I am also a member of the Board of County Commissioners, a member of the Health Board and the Air Pollution Control Board. My comments are different in that you're going to hear much commentary and have heard much commentary about the legal aspects and the technical aspects of this proposal, even some financial aspects. And my commentary is slightly different. And I want to begin my comments by noticing that while I respect your presence as a facilitator and hearing examiner, I'm very much disappointed that the Board of Health is not here present, and I want that noted. Our population, as the population of the state and the county and of course the United States increases, our resources continue to dwindle. Living within our environment becomes an increasingly challenging thing. Air quality issues in Missoula County are nothing new, and as each day passes, new challenges face us regarding maintenance of our breathable air. The county as a whole has responded by the country as a whole has responded by prompting Congress to enact numerous pieces of legislation aimed at not only protecting existing air quality, but improving it to acceptable standards. Since 1972, air quality rules have become much tighter with some remarkable results. Some of the technology changes I'll note. Technology has been developed and implemented, and as a result, we now have higher mileage and less polluting cars, cleaner and safer factories, and overall lessening of the rate of increase of discharge of pollutants into our airshed. These achievements did not come about by relaxing air quality standards, as this new rule would do. They came about because this country recognized the high-stakes game that we were playing with the health of our citizens, and we made the decision that the price of not making improvements was just too high. We think the stakes in Missoula County are just as high. I submit that the board's charge is to protect public health, and that this rule is counter to that charge, and I urge rejection of the rule.
Marilyn Craig.
My name is Marilyn Craig, and I'm Vice President of the Missoula City Council. The Missoula City Council met at its weekly meeting on April 3rd, 1995, and discussed the upcoming State Board, Health Board hearing regarding opacity requirements for the Kraft mills. A majority of the Council requests your consideration of the following comments regarding the proposed changes to ARM 16.8.1404, 16.8.1413, and 16.8.1429, dealing with opacity requirements of Kraft mills. The number 4 recovery boiler at the Frenchtown Pulp Mill was built in 1972 and is governed by a 20% opacity rule established in 1968 that was clear and unambiguous and has been included in Stone Container's permit. Additions to the mill and additions to the opacity rule have not changed this fact in any way. The existing rule should be enforced, not changed, to accommodate the inadequate precipitator on the boiler. Any action considered by the Board of Health and Environmental Sciences should have an impact on air quality equivalent to the enforcement of the 20% rule. An assessment of equivalency should be based on a thorough analysis using reliable data. The Board of Health and Environmental Sciences decision to use predetermined rulemaking to resolve this issue causes us some concern because of our desire for the public to be informed and to have an opportunity to present their concerns on issues affecting them. For these reasons, a majority of the City Council requests that the proposed rule be modified to require that any Kraft recovery boiler unit built after 1968 must meet a 20% opacity requirement. It is our understanding that the number 5 recovery boiler can easily meet this standard. Number 4 always should have. Having worked with our citizenry for the past 2 decades to improve Missoula's air quality, we cannot accept a weakening of long-standing air quality standards. We stand especially firm on this fact when we consider that all other sources in Missoula County built since 1968 must meet a 20% opacity rule, and in many cases 10%. Thank you for consideration of these comments.
Ma'am, if I could. Ms. Craig, for the record, could I ask what the vote of the City Council was in asking the board to make those amendments?
There was 1 no, and I can't quite, there were about 3 people absent and 2 passes, I believe. So that would be, well, whatever adds up to 12.
If I could ask you to go to include a copy of the council's minutes or whatever that vote was recorded in, so we can have it in our record, please.
You bet.
Thank
I'll do that.
Very much. You can just mail that to Yolanda Fitzsimmons.
Okay.
Thank you. Bill Rosbach.
Thank you. My name is Bill Rosbach. I'm a resident of Missoula County at 1533 Jackson, and I'm speaking here tonight on behalf of the Missoula City County Air Pollution Control Board, as a member of that board and as a member of the City County Health Board. I have some written statement with exhibits that I'd like to make a part of the record. Rather than go through that statement in its entirety, I'd like to kind of summarize what I say in that written statement and make some additional comments. First of all, I think I want to begin by saying that we would have to disagree very heartily with the statement that is made by the proponents that this proposed rule would operate to reduce the opacity. That is simply not true. The regulation is clear from the very beginning that the 20% opacity rule applies to the number 4 recovery boiler. The exception for NSPS qualified boilers clearly is not applicable. There's no ambiguity here. My first comment and my first objection, as stated in my statement, is that this rule, we object to the procedure that was used in adopting this rule or in proposing this rule. As Mr. Rusoff admitted, this rule is intended to resolve a legal dispute. As such, this turns normal rulemaking principles on its head. A settlement is not a rulemaking procedure. Rulemaking starts with the department proposing a rule, notice being given, comment being made, and then the board adopts or rejects the rule or modifies the rule. In this case, it is clear from the historical context as stated by the rule itself that this rule is intended to circumvent judicial review of a very flawed decision by the Board of Health. Those flaws, I think it is the most convincing and persuasive evidence of those flaws are in the petition for reconsideration that was filed by the Department of Health under the authorship of Mr. Rusoff. I would commend Mr. Rusoff, and I have made as an exhibit to my statement his petition for rehearing. That petition for rehearing, which is the first exhibit to my statement, shows clearly and unequivocally that there are very plain flaws in the board decision. The rule of 20% is clear on its face. There is no evidence in the record of the board hearing on the petition for on the July 4th hearing, no record to justify the ruling that it did. In fact, I've noticed that the only basis that is claimed in there is a sort of economic basis and an operational basis. It is notable, as Mr. Rusoff stated, that 5 out of 17 states that he surveyed have adopted a 20% opacity rule. Clearly and unequivocally, a 20% opacity rule is a rule that is at least a state-of-the-art rule. It is a rule that obviously many Kraft paper industrial operations have met in Ohio, Arkansas, Alabama. I can't remember the other states. So Wisconsin, Michigan. Clearly, these are states that have adopted such rules, and clearly it is economically and operationally feasible for a Kraft mill to meet those standards. I have a great deal of respect for Mr. Ball and the other workers at the plant, and I respect their opinions, and I have every reason to believe that this rule will have no effect whatsoever on the operation of Stone. Stone has admitted in court documents filed in this case that it will not shut down, that this change of 20% will not cause a shutdown. Stone and the Kraft paper industry in general are making tremendous profits. Now is the time to require a 20% opacity rule be confirmed. The big problem procedurally with this is that the settlement gave the department and the board no discretion and no independent judgment in adopting this rule. As such, it violates due process. It gave Stone a veto. Basically, the settlement provides that the rule has to be as agreed to and only will change after public hearing if both sides agree. Clearly then, this board and the DHES has given itself no discretion to change the rule unless Stone agrees. As such, Stone has a veto over the rule, and that violates fundamental principles of due process and the Administrative Procedure Act of Montana. The second point that I want to make is that there is no evidence scientifically, legally, or otherwise to support the 30% rule. In fact, at a December 14th hearing, well, let me start that. In the settlement agreement, there was an agreement that said at the December 14th hearing, there would be an explanation of the settlement. I was not present at that hearing, but I understand from review of the tapes and transcripts of that hearing that there was no explanation why Stone and the department had agreed to settle, and more importantly, why the department had agreed to give up on their petition for reconsideration when their own petition showed clearly and persuasively the error of the board decision. I will not recite that statement, and I'll ask again. Mr. Hutchinson, obviously you are quite aware of that, and I've made it an exhibit. It speaks for itself, and as I stated before, Mr. Rusoff should be commended. At that December 14th hearing, there was no explanation for a 30% opacity rule. It was pulled out of midair, apparently. There's no justification for it either in scientific evidence or economic evidence. There is no evidence of record of what impact this will have on the air of Missoula. I've stated in my statement that there are a number of unanswered questions that I'd like to make a record here today. What will be the difference in total emissions when opacity is raised to 30% instead of 20%? What role will this increase have in total airshed particulates in the valley? How will this affect the lung capacity in our children? We know that the lung capacity of the children of Missoula is reduced as a result of particulates in the valley. How will this affect hospital admissions for asthma and related lung conditions? How does it affect fog and other weather patterns in the valley? How does it contribute to changes in air dispersion? And most importantly, what is the cost to businesses, to people, to health insurers as a result of health effects of this particulates in the Missoula Valley? What lost business is there as a result of workers not being able to come to work? What loss of business has there been as a result of the fog out there at the airport when I and how many others of us have had to ride in from Great Falls because we can't get in because the particulate is contributing to the fog out there? Looking at the other side of the picture, we have no evidence of record as to the economic and operational effects that either a 20 or 30% rule will have on Stone. They have stated in court records that a 20% rule will not shut Stone down. The only evidence that we have been provided suggests that with some apparently minor exceptions, the 20% rule would be obtainable with the current equipment. And I'd like to point out that although this rule suggests that now they're going to impose continuous monitoring, they already have continuous monitoring. They've done this voluntarily. The second exhibit that I've made to my statement is a letter from Laura Kosmalski, environmental engineer at Stone, to Mr. Garen Smith, which shows that over a 3-day period with the recovery boiler running at 94% capacity, there were only very, very minor blips over 20%. So clearly, with the 20% rule, that can be met today with the current equipment if they only have the will to do that. Until these questions of economics are satisfactorily addressed, there is no legal, scientific, or economic basis for the rule. Lastly, I'd like to point out, and I'd like to refer the board to the last exhibit in this, which is an article from the Annual Review of Public Health. It's an article published by two researchers at the Harvard School of Public Health in Environmental Epidemiology. The title of the document is Acute Respiratory Effects of Particulate Air Pollution. With all due respect, particulates have grave and substantial economic consequences for the citizens of this valley in terms of increased costs of health care and loss of productivity. This annual review shows that they looked at 20 different air pollution studies worldwide. They did a meta-analysis of these studies and found that a 10 part per million increase in particulates will cause more than a 1% increase in actual mortality from respiratory and cardiovascular conditions. When we see in the valley sometimes a 50 part per million increase in particulates over a day or two, we would thereby be increasing by 5% actual mortality in this valley. That is, people dying from respiratory and cardiovascular conditions. The same study noted a 3.4% increase in hospital admissions for asthma as a result of only 10 part per million increase in the PM10. Likewise, it showed a 3% increase in bronchodilator use and other decreases in lung capacity and function. While there are many dispersed sources of particulates in the airshed, which we are now making valiant efforts to control through wood stove regulation, changes in sanding operations, Stone is a point source. It is a point source that plays a substantial role, 5 to 10% of the total particulates in downtown Missoula. That is a role that can be and should be controlled. We therefore urge rejection of the proposed rule as unsupported and unsupportable, and urge reconfirmation of the clear and ambiguous 20% opacity rule in these new regulations. Thank you.
Wayne Van Meter.
Good evening. My name is Wayne Van Meter. I live at 2224 and a half Rattlesnake Drive in Missoula. And my associations began about 1970, plus or minus a year or two, with the Air Pollution Advisory Council to the Health Board, which was then first organized. Since then, I have served on the Air Pollution Control Board and Health Board from 1981 to 1992. I retired in 1988 as a professor at the University of Montana in chemistry. Most of my comments have been already well taken up by other speakers. I would like to add a few very brief ideas. Over those 20 to 25 years that I have been involved in trying to get better air for the Missoula Valley, I have watched the people of this community struggle with not only with the industry, but also primarily with the state agencies, which should have been monitoring over the time, but really have not done an adequate job of enforcement. We have long been discouraged by the fact that testing that should have been done by the state has never been done. It would have shown whether and when 20% was enough. As has just been stated, 20% is a standard that is now held by many facilities all over the nation and could be well held here. It would be of great disappointment to the people of this community if the Board of Health now chooses to change in a deleterious direction even a label on the standards to which this pulp mill should operate. I was not ready to speak here until earlier this evening. I want you to know that I could not come here and listen to something happen without taking part, since I was a part of it for so long. I urge the board not to take this step. The idea that relaxation is not a thing that happens when 20 becomes 35 or 30 does not make sense. The statement made earlier by one of the representatives of the mill stated that relaxation of standards is not going to happen. That is correct if you consider all three recovery furnaces as a unit, as a whole unit. But for the number 4 boiler, it is a relaxation. They may not change their practices, I doubt that they will. But it is a psychological as well as a legal and technical change which I think that the people of this community would greatly deplore. Thank you.
Susan Spankel.
I'm Sue Spanky, and I'm a member of an alternate member of the Citizens Air Quality Advisory Council. And I'm not reading their testimony, I'm speaking for myself, but I think that they will say something soon.
Susan,
should I say?
were you referring to Bill Rosbeck's?
No, just a second ago, Dan handed you the advisory council's testimony. You put it at the bottom of your stack.
Okay.
But anyway, I'm a member, but this isn't their testimony. I would first like to express my regret that the health board is not listening in person to the citizens of Missoula who will be affected by their rulings. I strongly support regulations which will improve air quality and ask the board to enact only such regulations in the rules governing Kraft mill recovery boilers. I also ask them to address the dangerous pollution caused by other parts of the paper manufacturing process. I strongly oppose any rules which worsen air quality or allow the present unhealthy status quo. The proposed so-called compromise opacity levels are only one half of a very bad compromise, the half where the state gives away Missoula's right to healthy air. According to existing 6-minute data supplied by Stone Container to the Advisory Council, boilers 4 and 5 already operate within the proposed new limits, due at least in part to good pollution control equipment. The proposed opacity limit gives away the right to ask the biggest, most poorly equipped, most polluting boiler to be operated at established standards in return for gains which in reality are non-existent. They allow the only paper mill in Montana, which is located in one of Montana's highest population areas and most vulnerable air sheds, a valley where during winter inversions 70,000 people breathe not 1 minute's or 1 hour's or 1 day's particulate discharge, but the accumulated toxic particulate of up to 10 days total pollution. They allow this paper mill to operate at middle-of-the-road standards. These standards may work in locations with normal air circulation, but are totally and dangerously inappropriate here. The health board needs to make protecting the health of Montana people its #1 concern. Based on nationwide research, which was quoted a few minutes ago by Bill Rosbeck, inadequate control of pollution causes very real increases in health costs. Missoula's current average yearly level of particulate pollution causes about a 2% increase in total mortality, and this does not include any possible cancer deaths. This means an extra, unnecessary 10 deaths per year in Missoula, coincidentally the same number as we also have in traffic fatalities, which we spend untold time and money to prevent. At the level Missoula hits a stage 1 alert, daily cardiovascular deaths rise by about 10%, respiratory deaths rise by 24%, asthma sufferers have a 21% increase in asthma attacks, and a concurrent rise in doctor's visits. In the general population, coughs and lower respiratory symptoms increased by about 20%. This is a lot of missed school time, a lot of time off work, medical costs, and unnecessary human suffering. Industrial pollution does not cause all this suffering, but is a significant contributor. Stone Container, from the figures that I've heard quoted frequently, emits 7% of the most dangerous fine particulate in the Missoula airshed. Any corporation has the desire to maximize stockholder profits, but the Health Board has the responsibility to see that those profits are never subsidized by the health of Montana people. Opacity limits on boiler number 4 should remain at 20%. Opacity limits should be tightened on the other boilers, and the 6-minute reporting should be required. And I have a copy of this for you.
Thank you. Susan, is the Citizens Air Quality Advisory Council different than the Missoula City County Air Pollution Control Board?
It doesn't have any regulatory authority. It just provides information and technical advice to that board. They are
And
different.
it's a volunteer type organization, or are you appointed by some?
It's appointed organization by the board, actually.
The Missoula City County Air Pollution Control Board. Thank you. Ross Best.
My name is Ross Best. I live in Missoula. My address is Box 8303. I was pleased to hear that Commissioner Evans is recognizing concerns about conflict of interest involving her, and I'd like to comment on a conflict of interest matter that I've brought to the attention of the board in recent months. I learned today that Remington Court, a former member of the State Health Board, has been replaced on the board. I was pleased to hear that. I don't know whether that's the result of his decision or the governor's, but I think, as I'll explain, that was the right thing to happen. I'm going to talk about conflict of interest involving Remington Court. His last name is spelled K-O-H-R-T. And I'm going to talk about it because even though he's no longer on the board, we're living with decisions that he made while operating under a conflict of interest. Mr. Court was involved in the quasi-judicial proceeding that determined, for the time being at least, that the 20% rule was not required. The Missoula Health Department held a public hearing here in December, and I spoke on this subject then. And I believe it was in January that I attended the meeting of the state board, and I was pleasantly surprised that they spent about 20 or 30 minutes on this question. At the crucial times when decisions have been made by the board, Remington Court was the general manager and corporate secretary of Stoltz Lumber. Stoltz had contracts with Stone Container to sell wood chips and sawdust and to Stone Container. At the meeting in January, Mr. Court was present, and he had the opportunity to respond to my statement. He made no attempt to deny any of the factual statements that I had made. I think that under the circumstances, with Stone Container standing to have to spend an estimated $5 million on improved protection for our lungs, it's just a matter of common sense and common law that Remington Court should not have been participating in such a decision, particularly not a quasi-judicial decision of that sort. Jeremy Thane, who I understand has recently left the board, is a Missoula attorney, and at the January meeting, he questioned me for some minutes on the application of the state code of ethics and conflict of interest requirements. And one reason I'm bringing this up tonight is that it seemed to me that there was a general lack of familiarity among members of that board on what the law actually means. It was suggested that as long as a member of the board made a disclosure of a conflict of interest, that was okay. As long as you've disclosed, you can go ahead and vote, you can go ahead and participate. Actually, the Montana law dealing with what's called the rule of necessity, that is, the situations where someone must take action or no action can be taken, do not allow a blanket amnesty for conflicts of interest. They only apply in specific cases, and as I suggested in January, no members of the board had filed voluntary disclosure statements with the Secretary of State's office, as would have been required if they were to participate under the code. Remington Court did not just participate in the decisions involving Stone, he was pushing the action. I believe it was in July that the question came up, and Jeremy Thane indicated a willingness to postpone consideration of the question. He thought more time may be needed to consider it, but Mr. Court actually made the motion to approve the interpretation that Stone has put forward. I think that the State Board has an obligation to examine all actions that have been taken by Mr. Court in this connection. I think they should rescind their decision relating to the 20% opacity rule. I am hopeful that if the local Missoula board is allowed to intervene, that Missoula people may be able to push this issue in court. I would call on all members of the State Board to disclose anything that comes close to being a conflict of interest. The political climate today is, as everyone knows, not one that's willing just to take things for granted. I just learned that a lawyer in Bozeman, whose name I will probably mispronounce, Cindy E. Youngkin, Y-O-U-N-K-I-N, has been appointed to the board. She's an employee of the law firm of Moore, O'Connell, and Refling in Bozeman. And in a legal directory listing representative clients, I see that W.I. Forest Products is listed as one of the representative clients of that firm. I'm told that W.I. Forest Products is a firm, the W and the I stands for Washington and Idaho. This business is apparently a subsidiary or other part of Crown Pacific. I think that the members of the statewide board owe it to the people to declare what their connections are to industry, to the industries that they are regulating. And frankly, I would say that anyone who has that kind of connection shouldn't be on the board. There are a lot of people in Montana who are willing to serve on boards, and they don't have to be making money from the forest products industry. In conclusion, I would just say it appears to me that Missoula is the only area that's going to be affected by this rule, so the sentiment of Missoulians should be given a great deal of consideration. Thank you.
Mike Jarnovic.
My name is Mike Jarnovic. I'm representing the Missoula Valley Improvement Association, which is a clean air citizens advocacy group here. I feel that this whole discussion is pointless, for we all know the outcome. Stone is going to get their way because they are Stone, and Stone always gets what they want. And the whole issue of regulations concerning a 20% opacity standard versus a 30% opacity standard is moot because Stone doesn't obey the regulations anyway. That's what makes this whole discussion so ludicrous. They don't follow the rules to begin with. They don't obey the law. They don't pay the fines. They don't care. Garen Smith's editorial in the Missoulian today calls for a spirit of cooperation with Stone Container. There is nothing in this world that our organization would like better than to work constructively with Stone. But when ever has Stone Container given any indication of wanting to work with the community over mutual interests? Were they working for the good of the community when they convinced the legislature to remove local jurisdiction over Stone and turn it over to the state, the very agency that has now bowed down to Stone? Were they working for the good of the community when they tried subverting public input by preventing hearings from being held in Missoula? Stone has gone out of their way to undermine the best interests of the community for years. Why would they want to change now? And even if they did try and change, who would believe them? If Stone Container is truly interested in cooperating with the community, then why don't they make the first move and agree to the 20% opacity standard? Stone claims that to upgrade the number 4 recovery boiler would cost them $5 million. In 1993, Stone's Frenchtown Mill alone made over $590 million in sales. Yet they claim they can't afford the upgrade. They can, however, afford to run asinine commercials on TV telling us that civilization as we know it would disintegrate if they stopped making us white pizza boxes. This is the mentality that we face. Isn't it apparent by now that this debate has become redundant? Let's forget the opacity standard, which is a done deal, and go right for the lawsuit against the State Board of Health about who controls the destiny of the Missoula Valley. If we can win in that arena, then we can pursue what ultimately must happen, giving local jurisdiction back to the community that is most affected by Stone Container's pollution. Thank you.
Jay Kralik. Sorry if I mispronounce your last names.
Good evening. My name is Jake Krylik, and I'm a forest campaigner with the Native Forest Network. I want to focus on a couple of issues of concern to our organization. First off, I want to address the issue of corporate accountability. It is our contention that Stone Container has operated in a completely rogue fashion since the corporation acquired the mill from Champion International in 1986. We say this based on a consistent pattern of air quality violations from the Frenchtown facility. The violations pertain to air quality standards for hydrogen sulfide, totaling 751 violations from January 1989 through February 1991, and then 142 more violations from January 1992 to July 1993. Interestingly enough, the Montana Clean Air Act allows for 1 exceedance per year for hydrogen sulfide. Additionally, Stone has violated permit conditions for total suspended particulates on its number 3 and number 4 recovery boilers in November 1988 and December 1992. Violated total reduced sulfur standards 6 times on the number 4 lime kiln recovery boiler and once in December 1992 as well. It has violated the 20% opacity standard, which we're here to address tonight, several times. Violated opacity monitoring standards by incorrectly setting pollution monitors on number 5 recovery boiler, and circumvented air pollution monitors on number 4 lime kiln by venting non-condensable gases into the air. From January 1990 to February 1994, there were 234 instances where non-condensable gases, mainly sulfur-based chemicals that emit a rotten egg smell, of which we all know that smell. These were vented into the air for a period of 1,097 hours from Stone's air stripper and batch digester. During this period, there were 2 times, totaling 16.1 hours in September 1992, when the company intentionally vented these gases. Stone has violated the Federal Clean Air Act on numerous occasions, including the provision of prevention of significant deterioration from nitrogen dioxide for 8 months in 1993. They've also failed to adhere to the Clean Air Act's new source performance standards for particulate matter and the Act's state implementation plan for carbon monoxide, particulate matter, and particulate matter of 10 microns or less, and they have indicated no schedule for compliance. Stone received 17 violations of nitrogen dioxide standards and 2 violations of nitrogen oxide standards from 1990 to 1994 on 1 identified boiler. Lastly, Stone has logged 12,807 hours of continuous pollution monitoring failures from its number 4 lime kiln, number 5 recovery boiler, and its waste fuel boiler. According to the U.S. Environmental Protection Agency's Compliance Profile Report, which was released on August 5, 1994, Stone has been cited by EPA for violating opacity standards, intentionally venting hydrogen sulfide, sulfuric acid, and other sulfur-bearing substances, and incorrectly setting pollution monitoring devices. The company has never been fined or penalized for any of these violations. It is the Native Forest Network's position that any attempt to increase Stone's air pollution, given their toxic track record, will be met with stiff resistance from our organization and from the community at large. The second issue of importance to the Native Forest Network concerns Stone's waste fuel boiler, which burns plastic, PVC, and styrofoam, thus producing organochlorines. We were shocked to find out that there has never been a stack test at this mill, and that Stone has based its figures on extrapolations taken from 2 solitary samples from an unknown facility. According to the Department of Health and Environmental Sciences here in Montana, they estimate that Stone's waste boiler is being fed 130 pounds per day of chlorine. However, according to Stone's estimates, as much as 700 pounds per day of chlorine could be fed to the waste fuel boiler. This amount of chlorine, in either case, is bound to produce enormous amounts of extremely toxic and persistent organochlorines, such as dioxins, and hence poses a grave risk to the health of many residents in the Missoula Valley. I think in terms of what's happened with the collusion between the State Board of Health and Stone Container Corporation, the only result, the only outcome is for us to end up in court or for us to end up out at that mill trying to enforce the laws as citizens of the state and of this community. And you leave us very little choice. I'd like to address also the impacts that Stone has on the Clark Fork River and its water quality, and also the impact it has on forests and the landscape in general in our region, but I'll save that for another day. Thank you.
Jake? Could you give me some information about the Native Forest Network, what kind of organization it is and who are members?
It's a nonprofit environmental organization that focuses on temperate forest issues and campaigns. And we work internationally, but we have an office here in Missoula.
Thank you. Daryl Geist.
Thank you. Thank you, Will, for coming to Missoula. I speak today on behalf of our organization and many concerned citizens in our community who are simply outraged that the proposed implementation of an agreement between Stone Container and the State Board of Health will further pollute Missoula's airshed with toxic chemicals. There is no doubt that this agreement will result in health impacts and chemical injury to our families, friends, children, and neighbors. Yet, not one piece of evidence has been presented by the board or Stone Container to determine the health effects this agreement will have on our community. In response to the state and federal government's abdication of their responsibility to protect the public health and welfare of our community, the coalition of Montana-based groups has proposed a 6-point list of solutions to significantly improve Missoula Valley's airshed, the Clark Fork River, and help save the region's forest ecosystems. These include zero chlorine use facility-wide, including the conversion of the bleach pulping process to a non-toxic, non-bleach-based system to eliminate dioxin-producing chemicals. 2, disallow burning of toxic and solid waste such as plastic, PVC, and styrofoam in the waste fuel boiler. 3, maximum 20% opacity for all recovery boilers, and a reduction in allowable opacity on the number 4 recovery boiler to 10% by 2000. Incentives for converting the mill to 100% recycled post-consumer fiber operation. 5, citizen enforcement provisions. And 6, local jurisdiction. The following groups have endorsed this proposal, and they include the Alliance for the Wild Rockies, Chemical Injury Information Network, Cold Mountain Cold Rivers, Ecology Center, Friends of the Bitterroot, Montana Environmental Information Center, Missoula Valley Improvement Association, Native Forest Network, Wounded Earth Environmental Project, Women's Voices for the Earth, and Voice of the Environment. We respectfully request that the Board of Health and Environmental Sciences scrap this proposed agreement and adopt the 6-point list of solutions that, taken together, will significantly reduce health impacts and chemical injuries to Missoula residents, as well as improve the air and water quality and save precious forests. I thank you for your time and consideration of these citizen-proposed solutions.
There are the 6 points on the sheet that you mentioned. Thank you. Okay. Thank you. Jason Klemper.
Yes, my name is Jason Klempner, and I was an employee at a medical waste incinerator in the Bronx, in New York City, and it's pretty much essential that there's a 24-hour opaque monitor that functions every 6 minutes, but that in itself is not enough. There needs to be very strict standards of at least 20%. They can probably get it down to 10%. The part of the particular emissions at a medical waste incinerator is very much like those at Stone Container. They can get it down to 10%. It'll cost money, but they will be able to reduce particulates and increase production, and even make profit by doing that. It's very disrespectful to the community at large. We have to breathe in the bad air so that they can make money. There's only a few men who are making this money. They don't help the community. They don't care about the community, but yet the community has to suffer for their wealth. I do respect I do understand that they do employ 400 people, but that's not good enough. They have to, it's very disrespectful to the community, and we're not going to take this. They're going to have to get more technology. They're going to have opacity meters 24 hours a day. They're going to have to lower their particulates to 20% or less. There's no reason why it can't be less. They'll still be able to produce more, make profit. We're not going to allow this disrespect to go on anymore. And it's just not right. We're going to say no, that they're not behaving in a way that's proper to the community, and we're just going to say no.
Brad Hesh.
My name is Brad Hash. I live at 322 Adams Street in Missoula. I am a concerned citizen speaking here tonight. I intended to speak here tonight with the belief that what I would say as a Missoula resident would actually be taken into account by Stone and the Board of Health and Environmental Science in their proposed agreement. Now I've learned that the agreement has been made and the residents of the affected area have been shut out in this decision-making process. How convenient. Stone's Board of Directors do not live in the valley. I do. The Montana Board of Health and Environmental Sciences does not live in the valley. I do. Most of the people in this courtroom live in this valley. Stone's Board and the Board of Health and Environmental Sciences do not have to live with the outcome of their decision. We do. I am outraged that this decision did not represent the Missoula Valley residents. We are supposed to be living in a democracy, by the people, for the people. Right. Doesn't it bother you a little, Stone, that you are the #1 releaser of air toxins in the state of Montana at 891,104 pounds a year? That is by the newly released EPA figures that came out on Monday, and that is for 1993. And doesn't it bother you a little, Stone, that you're the #2 releaser of water toxins in the state of Montana at 69,850 pounds a year, that too being from the newly released report from the EPA. So doesn't it bother you a little, Stone, that you made an agreement directly affecting the health of all the valley's 70,000 to 80,000 residents, not to mention your own employees? Stone is wanting to take further advantage of Montanans and continue to discharge an unacceptable amount of emissions in our valley. We are asking that you be held accountable for your actions and you just behave responsibly. Other pulp and paper mills do it. Why can't Stone? I started a petition yesterday morning requesting that Stone and the Board of Health and Environmental Sciences include the following demands in their agreement. These demands were drawn up originally by the coalition of environmental groups in the area, and as I've learned, since been modified. I will read them to you as they are stated on this petition. #1, zero chlorine use facility-wide, including conversion of the bleach pulping process to a hydrogen peroxide-based system. #2, the disallowing burning of toxic waste in the waste fuel boiler. #3, a maximum 20% opacity for all recovery boilers, including reduction of allowable opacity for the #4 recovery boiler to 10% by the year 2000. #5, incentives for the increased use of 100% post-consumer recycled fiber in mill production processes. And finally, citizen enforcement provisions. This petition that I have here accumulated 340 signatures in less than 48 hours. I'd like to end by saying, Stone, you cannot keep shutting us out. We will persist, and we will and must be included in the equation when our health is at stake. Thank you.
If you want to give it in, include it in the record, you can. Has to be in time. Okay. Bruce Ammons.
My name is Bruce Ammons. I live at 648 West Crest Line here in Missoula. I've been a Missoula resident all my life. I'm a Missoula resident. I've been a Missoula resident all my life, except for the 6 years I went away to graduate school back east where the air was cleaner. I hate to say that, but I was a member of the Air Pollution Advisory Council here, now called the Air Quality Advisory Council, for 7 years. until various things took me away from that, I'm still there with my heart, and that's one reason I showed up tonight. I believe that the air quality here in Missoula should be of concern to all citizens, and I'm really pleased to see the number of people who did show up here. As badly advertised as these sorts of things usually are, it never ceases to amaze me how many people do take the time to show up. I'm also pleased that people have made many of the points that I had in my notes. I'm not sure if it helps for me to reiterate those things, so I will only do that very briefly. I'm concerned about, I came here gravely concerned about the process for adoption of this rule as it stands to date, in that there was no local decision making, except my understanding is that basically the board asked Stone to write up something they would find acceptable, and that was what was worked upon. I don't think that's how we really want to do things. I agree that our Board of Health for the state and our local Board of Health have a real duty to the citizenry to be proactive and not reactive in cases of public health. I'm concerned that this whole process took place outside of Missoula until tonight. It's very difficult for those of us who work for a living and have children here in the valley to make our way over to Helena every time there's some meeting. And it's very difficult, in fact, to even find out when such meetings are occurring. That doesn't mean we're not concerned. It doesn't mean that we wouldn't speak if we were given the chance. I would hope that in the future that the state board would have hearings here early in the process so that they can hear how people who actually live in this valley feel about this kind of issue. I'm concerned that there are no board members here. I consider that a real insult. I think they all ought to be here tonight if they really intended to hear what Missoulians had to say. I think this was some sort of action after the fact, sort of, well, we'll do this just because it looks good or something. I'm concerned about that. Anyway, I have a cynical nature about these kinds of things from having dealt with these kinds of issues for a number of years. I'm concerned that many things have been very misrepresented by Stone. This is something which, I mean, as long as I've had contact with air issues in the valley, this has been the case. We heard from an employee earlier that all the wonderful things which Stone had done to improve the air quality voluntarily. I would like to speak just about one of those, which was the $750,000 which was spent to reduce H2S pollution. That only came after the state board had ignored huge numbers of violations of that standard. I mean, huge numbers, as we heard from the gentleman who spoke earlier. We're talking about like 900 of them. When our council looked into that, we just looked at 80 or 90 of them because we only looked at a very brief period of time. When we pushed that, because we were concerned that the state had not responded to those violations, it was only after a lot of pushing and shoving that Stone decided to do anything about that. That was certainly not something which they proactively did. You know, Missoula has a very unique topography, and as such, with its growth that it's now experiencing, it's deeply in trouble with this airshed. I would venture to guess that we have overextended the number of people and cars and so on that the Missoula Valley can truly handle from a human health point of view by at least a couple of times already, and it continues to grow. We can't really do that much about that growth. Certainly, Mr. Kennedy and some others on the county commissioners and so on, and the city council can try to address some of those issues of growth, but I think that it will continue regardless. And given the huge amount of work that's been done by local officials in the city county health department, by all the folks who've shown up to all the public hearings on any sort of air matter, by the folks who've served on the Air Pollution Advisory Council, and everyone else that I can't even think to mention here. It's a huge number of people who've really put their hearts into this. who've worked on stove laws, who've worked on what do we do about car emissions, what do we do about road dust in the wintertime, coming up with solution after solution, and considering what do we do about industrial sources. It's a real insult to have the state board come to us with a rule that seems like a done deal already, and not include Missoulians in this whole process until the tail end, when it seems to me, and I could be wrong, but it seems to me it's really too late. We're all here, you know, trying to have our say, but my feeling is that it's already been done. I hope that's not true. I hope that what we're saying here tonight really does matter. I think there are routes people will pursue to make sure that it does, but I think it's a real insult to see that undone with a point source which can be controlled and which indeed has misrepresented their case all the way along. As far as in any of these sorts of discussions, I'm always appalled when I hear authority bandied about in order to convince folks of certain arguments, and I'm specifically referring in this case to speaking of these new source rules for controlling particulate emission. When they say new, I believe that most of those rules were formulated many, many years ago. It always takes a long time to get those sorts of regulations considered and talked about and passed, so that they're always inevitably far out of date.